Rule 131, Section 3. Disputable presumptions. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. That a person is innocent of crime or wrong. That an unlawful act was done with an unlawful intent. That a person intends the ordinary consequences of his voluntary act. That a person takes ordinary care of his concerns. That evidence willfully suppressed would be adverse if produced. That money paid by one to another was due to the latter. That a thing delivered by one to another belonged to the latter. That an obligation delivered up to the debtor has been paid. That prior rents or installments had been paid when a receipt for the later one is produced. That a person found in possession of a thing taken in the doing of a recent wrongful act is the taker and the doer of the whole act. Otherwise, that things which a person possesses or exercises acts of ownership over are owned by him. That a person in possession of an order on himself for the payment of the money or the delivery of anything has paid the money or delivered the thing accordingly. That a person acting in a public office was regularly appointed or elected to it. That official duty has been regularly performed. That a court or judge acting as such, whether in the Philippines or elsewhere, was acting in the lawful exercise of jurisdiction. That all the matters within an issue raised in a case were laid before the court and passed upon by it, and in like manner that all matters within an issue raised in a dispute submitted for arbitration were laid out before the arbitrators and passed upon by them. That private transactions have been fair and regular. That the ordinary course of business has been followed. That there has been a sufficient consideration for a contract. That a negotiable instrument was given or endorsed for a sufficient consideration. That an endorsement of negotiable instrument was made before the instrument was overdue and at the place where the instrument is dated. That a writing is truly dated. That a letter duly directed and mailed was received in the regular course of the mail. That after an absence of 7 years, it being unknown whether or not the absentee still lives, he is considered dead for all purposes except those of succession. The absentee shall not be considered dead for the purpose of opening his succession till after an absence of 10 years. If he disappeared after the age of 75 years, an absence of 5 years shall be sufficient in order that his succession may be opened. The following shall be considered dead for all purposes including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage or an aircraft which is missing who has not been heard of for 4 years since the loss of the vessel or aircraft. 2. A member of the armed forces who has taken part in armed hostilities and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances and whose existence has not been known for 4 years. 4. If a married person has been absent for 4 consecutive years, the spouse present may contract a subsequent marriage if he or she has well-founded belief that the absent spouse is already dead In case of disappearance, where there is a danger of death, the circumstances herein above provided, an absence of only 2 years shall be sufficient for the purpose of contracting a subsequent marriage. However, in any case, before marrying again, the spouse present must institute a summary proceeding as provided in the family code and in the rules for declaration of presumptive death of the absentee, without prejudice to the effect of reappearance of the absent spouse. We now continue with the disputable presumptions under Rule 131. Letter X. That acquiescence resulted from a belief that the thing acquiesced in was conformable to the law or fact. That things have happened according to the ordinary course of nature and ordinary natural habits of life. That persons acting as co-partners have entered into a contract of co-partnership. That a man and woman deporting themselves as husband and wife have entered into a lawful contract of marriage. That property acquired by a man and a woman who are capacitated to marry each other and who live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage has been obtained by their joint efforts, work, or industry. That in cases of cohabitation by a man and a woman who are not capacitated to marry each other and who have acquired property through their actual joint contribution of money, property, or industry, such contributions and their corresponding shares, including joint deposits of money and evidences of credit, are presumed equal. That if the marriage was terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof to the contrary. 1. A child born before 180 days after the solemnization of a subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. 2. A child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. That a thing, once proved to exist, continues as long as is usual with things of the nature. That the law has been obeyed. That a printed or published book purporting to be printed or published by public authority was so printed or published. That a printed or published book purporting to contain reports of cases adjudged in the tribunals of the country where the book is published contains correct reports of such cases. That a trustee or other person whose duty it was to convey real property to a particular person has actually conveyed it to him when such presumption is necessary to perfect the title of such person or his successor in interest. That except for purposes of succession, when two persons perish in the same calamity such as a wreck, battle, or conflagration, and it is not shown who died first, and there are no particular circumstances from which it can be inferred, the survivorship is determined from the probabilities resulting from the strength and the age of the sexes according to the following rules. 1. If both were under the age of 15 years, the older is deemed to have survived. 2. If both were above the age of 60, the younger is deemed to have survived. 3. If one is under 15 and the other above 60, the former is deemed to have survived. If both be over 15 and under 60, and the sex be different, the male is deemed to have survived. If the sex be the same, the older. 5. If one be under 15 or over 60, and the other between those ages, the latter is deemed to have survived. That if there is a doubt as between two or more persons who are called to succeed each other as to which of them died first, whoever alleges the death of one prior to the other shall prove the same. In the absence of proof, they shall be considered to have died at the same time.